I want you to think about someone for a second. I'll call him Robert. He did everything right. He started contributing to his 401k at 28, never touched it during the lean years, lived modestly, drove the same car for 11 years. By the time he was 60, he had just over $1 million in his retirement accounts. $1 million. Most Americans never get there. And Robert did it as a mid-level operations manager at a logistics company in Ohio. Not a Wall Street guy, just a regular, disciplined man who chose tomorrow over today, again and again, for more than 3 decades. He retired on a Tuesday in March, threw a small party at the office, walked out with the biggest smile his co-workers had ever seen on him. His financial planner signed off. His accountant signed off. He had a Roth IRA, a traditional 401k, a small pension, and a brokerage account. He had a Social Security strategy. Medicare was locked in at 65. By every financial metric, Robert was set. He died at 67. A heart attack. Sudden. And here is what happened next. His 401k, worth just over $847,000, did not go to Sandra, his wife of 12 years. It did not go to his 3 adult children. It went to a woman named Deborah, his first wife, the one he had divorced 15 years earlier, the one he hadn't spoken to in over a decade. Deborah received $847,000 because Robert had listed her as sole beneficiary in 1998, and in 23 years of careful financial planning, not one person had ever told him to go back and check that single form. I'm Carol Ann Mitchell. I spent 24 years as a retirement and estate planning attorney in Scottsdale, Arizona. Certified financial planner since 2001. I helped over 600 families transition into retirement. And I cannot tell you how many times I sat across from a surviving spouse who had just learned that the person they built a life with had unknowingly left them financially exposed because of one legal detail nobody ever told them to check. Stay with me on this. What I'm going to share today may be the most important thing you hear about retirement planning all year. There is a number that lives in people's heads. For some, it is 500,000. For others, it is 1 million. And when they reach it, something in the body relaxes. The shoulders drop. They lean back and say, "Okay, I think we are finally there." That feeling is not wrong. Reaching $1 million in retirement savings is a genuine achievement. It represents decades of discipline and sacrifice. I don't want to take that away from anyone. But here is the thing. That number is only one leg of a 3-legged stool. You have the financial leg, your savings and income plan. You have the healthcare leg, Medicare and supplemental coverage. And then you have the legal leg. And the legal leg is the one that gets neglected the most, by everyone. Including, I'll admit with some embarrassment, by some of my own clients who came to me specifically for estate planning. Robert is a real person. I changed his name. But the facts are real. I knew his family. Sandra, his wife, was my client. She came to me after he died, not before. And that is the part that still weighs on me. When Robert retired at 60, he did a thorough financial review. He optimized his 401k rollover, mapped out Social Security, projected his income and expenses. He and Sandra talked about travel about the grandchildren, about the road trip through the southwest and the trip to Portugal they had been planning for years. They had good, solid plans. What Robert did not do was sit down with an estate planning attorney and verify that the legal documents attached to every account still reflected his current life. Because in 1998, when he enrolled in his 401k, he was married to Deborah. He put her name on the form. Then 23 years of life happened. A divorce, a remarriage. He updated his will. He changed his life insurance. He updated one old pension. But his 401k? Nobody flagged it. Nobody checked. And under federal law, specifically ERISA, the beneficiary designation on a qualified retirement plan overrides your will. Completely. It doesn't matter what your will says. It doesn't matter how long you were married to your current spouse. The name on that form receives the money. Full stop. Courts have upheld this, even in cases where the account holder's intent was documented and undeniable. Even when they had spoken to their advisor about wanting to change it. Intent does not count. The completed form counts. Boy, I remember a case early in my practice where a man had written a signed letter to his financial institution stating he intended to change his beneficiary. He just never submitted the actual form. His ex-wife inherited the account. The letter was inadmissible. The form controlled everything. Now I want to walk you through why this matters beyond Robert's specific situation, because this is not a rare problem. Think about all the life transitions you have had in the last 20 years. Marriages, divorces, the death of a parent who was listed as a beneficiary. Children growing from minors to adults with families of their own. A falling out with a sibling who was once your trusted backup. A new grandchild you would want to include. Each one of those transitions is a moment when your beneficiary designations could quietly fall out of sync with what you actually want. And most people never go back to check. They are focused on the account balance, on the return, on the contribution limit. The form itself, that single administrative document that legally overrides everything else, gets forgotten. I had a client named Patricia, 63 years old, who had done a wonderful job saving, about $780,000 across a current 401k and a rollover IRA from a job she had left back in 2009. When we reviewed her IRA, the primary beneficiary listed was her mother. Her mother had died 6 years earlier. There was no contingent beneficiary on file at all. Do you know what happens to a retirement account with no living beneficiary? It goes through probate. It loses its tax-advantaged status. Instead of her heirs being able to stretch distributions over a decade and let that money keep compounding, the full amount would need to be distributed within a compressed window, fully subject to income tax at ordinary rates. Patricia could have lost 35 to 40% of that account to taxes that could have been strategically managed or largely avoided. All because no one had looked at that form since 2009. She fixed it that same afternoon with a one-page form and 30 minutes of her time. But she had to know to look. That is always the key, knowing to look. The hidden danger is a category of quiet, unsexy administrative oversights that accumulate over years of ordinary life. Beneficiary designations are the most common. But there is also account titling, joint tenancy versus tenancy in common versus community property. 3 options with profoundly different implications that most people select without knowing what they mean. There is also the matter of your durable power of attorney. If you become incapacitated, who has legal authority to manage your financial affairs? If you do not have one in place, the answer may be nobody, or a court appoints a guardian. I watched that process take 18 months and cost $45,000 in legal fees over someone who had $2 million in assets and a spouse who desperately needed access to pay for care. The legal layer is not optional. It is not a formality you handle once and forget. It is a living part of your financial plan that needs the same regular attention you give your investment allocation. Now let me tell you what actually happened to Sandra. Because Robert's story does not end when he dies. Sandra came into my office 2 weeks after he passed. She was not just grieving her husband. She was simultaneously trying to understand how their financial plan, which had looked so careful and complete, had this enormous hole in it. Deborah's attorney contacted Sandra's attorney within 6 weeks of Robert's death. There was no dispute about the legal facts. ERISA was clear. Federal precedent was clear. Deborah was entitled to the money. Every dollar of it. Sandra had the house, which transferred to her through right of survivorship. She had a joint brokerage account with about $120,000. She had Robert's small pension survivorship benefit. She was not destitute. But she had expected to share approximately $1.2 million in retirement assets for what she hoped would be 20 years of healthy life together. Instead, she found herself at 64, recalculating everything. Figuring out how to make $120,000 in a brokerage account, a house she now owned alone, and a modest pension sustain her for the next 2 or 3 decades. And Deborah, who had her own life, who had not spoken to Robert in over a decade, received $847,000. She found it profoundly uncomfortable to accept, from what I understand, but legally she was entitled to it, and there was nothing anyone could do. I want you to know what those 7 years of retirement looked like for Robert and Sandra, because they were genuinely good years. The road trip through the Southwest, Portugal. Robert took up woodworking. Sandra started a book club. They were at every soccer game and every school play for the grandchildren. From the outside, from the inside too, it looked exactly like what retirement is supposed to look like. 7 full, vibrant years. That is what makes this story so difficult to sit with. Robert did so much right. He saved $1 million. He retired at 60, while healthy enough to fully live the life he had imagined. The mistake was not in his character or his diligence. It was in a form from 1998 that no one had ever told him to revisit. Here is what the research tells us. Studies consistently find that between 30 and 40% of Americans have beneficiary designations that are outdated, incorrect, or missing entirely. Nearly a third of people who have gone through a major life event like a divorce have never updated those designations. This is not rare. This is not something that only happens to disorganized people. It is sitting, right now, in hundreds of thousands of households, invisible and quiet, until the day it suddenly is not. I will tell you something personal. When I retired in October of 2023, one of the first things I did was pull out every account statement I owned and review every beneficiary designation. And I found one. An old rollover IRA from 2004. Primary beneficiary, my father. My father died in 2018. No contingent beneficiary. 5 figures sitting in an account that would have gone through probate if something had happened to me. I am a retirement and estate planning attorney with 24 years of experience. If it can happen to me, it can happen to anyone. So let me give you 4 concrete things you can do right now. First, and I want you to do this week, conduct a beneficiary audit. Pull out every financial account you have, every single one. Your current 401k, any old 401k accounts from former employers, your IRA or Roth IRA, life insurance, annuities, any accounts with payable on death designations. For each one, ask, who is the primary beneficiary? Who is the contingent backup? And is that information still accurate for your current life? If you have married, divorced, lost a listed beneficiary, or had grandchildren you want to include, update the form. It is usually 1 page, often online. It costs nothing, and it takes 20 minutes. That 20 minutes is what could have saved Sandra $847,000. Second, if you do not have a current durable financial power of attorney, please get one drafted. This gives someone you trust the legal authority to manage your finances if you become incapacitated, not when you die, but if a stroke or illness leaves you unable to act on your own behalf. Without it, the courts decide who manages your affairs, and that process is slow and expensive. Third, if your will or trust has not been reviewed in more than 3 years, call your attorney and schedule a review. Your life changes, tax laws change. What you owned and wanted at 55 may be different at 65. Every 3 years minimum, and after any major life event. Fourth, ask your financial advisor whether beneficiary reviews are part of their client service. Some do this comprehensively, others never look at the legal layer. If yours does not, an estate planning attorney can fill that gap. Now I want to close with something beyond checklists. Because I am also someone who retired 8 months ago and thinks about Robert not just as a case study, but as a man who made a brave decision. He retired at 60. He chose to live while he still had the health and the energy to live fully. He and Sandra had 7 real, joyful years together. He did not defer his life. At 60, he had roughly 1,000 healthy, active weeks ahead of him, and he used them. That matters. The tragedy is not that he died. We all die. The tragedy is that one form from 1998, one line he had no reason to revisit because nobody told him to, meant that the financial cushion he spent 30 years building did not protect the person he most wanted to protect. You can always update a form, but you have to know to do it, and then you actually have to do it. Not next month, not after the holidays, this week, while it feels real and urgent. Because that urgency fades. Life gets full again. What feels critical today becomes something you will get to later. And later becomes 15 years. And 15 years becomes $847,000 going to someone you divorced in 2003. You have a finite number of healthy, active weeks ahead of you. We do not know exactly how many. The legal work, the beneficiary audit, the estate review, that is the scaffolding that protects everything you have built from being undone by something preventable. Build the scaffolding, then go live the life. This is educational content only, not legal or financial advice. Please work with a qualified estate planning attorney and financial advisor who know your specific circumstances. But do not wait to start asking the right questions. The right time is now.